Fellow jurors, Ambassador Butler, Sujin, Musa, Lisette, we have an important decision to make. Before getting into the discussion, I thought it would be best to articulate the two questions and
Please.
issues we have before us.
Good.
The first question: has France violated 18.1 of the International Covenant on Civil and Political Rights? Article 18.1 reads, "Everyone shall have the right to freedom of thought, conscience, and religion. This right shall include the freedom to have or to adopt a religion or belief of his choice, and freedom, either individually or in community with others, and in public or private, to manifest his religion or belief in worship, observance, practice, and teaching." Our answer to that question will drive whether we even get to the second question. If the answer to one is yes, we must answer a second question, and that is France accepted by Article 18.3 of the International Covenant on Civil and Political Rights, despite having infringed on the freedom of religion provided under Article 18.1. 18.3 reads as follows: "Freedom to manifest one's religion or beliefs may be subject only to such limitations as are prescribed by law and are necessary to protect public safety, order, health, or morals, or the fundamental rights and freedoms of others." A complicated question and issue and a short amount of time to deliberate. Why don't we start with the first question and get everyone's thoughts on the issue, beginning with Ambassador Butler.
Okay, thank you, Shobha. I'll try and come very quickly to the point because we do have only a short time. In the law passed by the French Parliament, the word conspicuously was used, and I thought that was very important. The concept of a person in their attire exhibiting conspicuously a religious affiliation. Now, we've heard talk in the courtroom about small crucifixes, Jewish yarmulke or keffir as they're called, turbans for Sikhs and so on. But this concept of whether or not a headscarf represents a conspicuous expression of religion, it seems to me has been inadequately addressed. In fact, I go further and say that the whole issue of this so-called headscarf law has been completely inadequately addressed. I've not heard anything to demonstrate what seems to be the popular view, that this is all about Muslim women and their headscarf. To make that clear, there's an assumption here that worries me deeply, that this is just about Muslim women and their headscarves. I'm not sure that that's true. What the French Parliament has talked about is conspicuous demonstration of a religious affiliation. By the way, it's not even clear to me that wearing of the headscarf does in fact derive from the Quran, but it's just a cultural practice. That's perhaps too big a subject for us. I want to focus on, first and foremost, this notion of conspicuous demonstration in public of a religious affiliation, and express my doubt that wearing a headscarf necessarily constitutes, meets that definition of a conspicuous demonstration. Now, then when one turns to the International Covenant, which you've asked us particularly to focus on, and I agree with that, I'm not sure that France has behaved properly in seeking to restrict, if it is the case, restrict the ability of Muslim women to wear a headscarf. If they were to do that, they would have to turn to Article 18.3 and use one of the 5 reasons given there for saying that Muslim women may not do this because it offends public order or health or safety, but we'll perhaps come to that. But my inclination at the present time is to express doubt that wearing a headscarf does represent a conspicuous demonstration of religious affiliation. I think that's been done unclearly, and I doubt, and to express my doubt, that in banning, if this is the purport of the law, and it appears to be, in banning the ability of Muslim women to wear a headscarf in a public school, that France in fact is behaving consistently with Article 18.1 of the International Covenant.
Thank you, Ambassador. Did anyone have a reaction or response to his remarks? Or if not, we'll go just around the table first and get initial reactions to the first question.
Okay, I think that International Covenant on Civil and Political Rights stipulate that everyone shall have the right to freedom of religion, and this religion shall include the freedom to publicly or privately manifest his or her religion and practice. So I thought that for these Muslim girls and for any other students who believe in Catholic or any other religion, when they carry the visible religious symbols such as cross or headscarves, I think it is for me, it is pretty clear and specific according to ICCPR that it has to be respected. It shall be the rights of these people. So in that respect, the French law prohibiting the conspicuous religious symbols would be, in my opinion, would be the violation of the terms of the ICCPR. That's my opinion.
I have to agree with Sujin and Ambassador Butler as well. I think you look at the wording of 18.1 of the ICCPR, and you quickly come to the determination that the way that the law is written, it will exclude some people, and essentially what it is saying is your freedom stops where that of others would begin. So the right of those who come to school and the right to not wear religious symbol, the right to have that enjoyment supersedes that of your right to wear your religious symbol externally and to manifest that, whether it's in public or in private. So therefore, you have to take into consideration whether or not we believe that, the wearing of the headscarf is actually something that's mandated in Islam is irrelevant, because at some point there is somebody who believes that it's an active part of their religion, their faith, and their worship, and therefore the law is indeed limiting that. Whether that is a Muslim girl who is being forced into worship by wearing the headscarf, or it's one who chooses to wear the headscarf, somebody is being limited. And therefore it's an imposition that automatically violates 18.1.
I agree with everyone's points so far. I actually think that Ambassador Butler brings up a really good point in terms of, or with regard to whether or not a headscarf is indeed de facto even a religious.
It's totally confused, isn't it?
Religious a symbol of religious affiliation in and of itself. I mean, if someone just wanted to wear a headscarf, they probably could, right? Or any other symbol, which doesn't automatically mean that they are expressing a particular religious belief. That said, it seems that the way that the law has been practiced, right, has been specifically in this context only. And because of the way it's been put into effect, it seems that it is actually going against these young girls or whoever does choose to use or wear the headscarf in a public setting. But I think that the first point is a really interesting one as well, because I'm not convinced either after thinking about it that one necessarily, just because you're wearing a particular symbol even means that you're ascribing to a particular faith to begin with.
Perhaps the French might feel differently if the headscarves were made by Christian Dior or Chanel. You see what I'm saying? I mean, there are different kinds of headscarves, but anyway.
I think that before we can even, there are lots of vagaries and insufficiencies that don't help us really answer the first question, but that have been really well pointed out by all of you, beginning with what is conspicuous. And unfortunately, we don't have the time to answer that question today, though it is a really important one. As I was listening to the deliberation, I was looking at my Manglam Sutra, which is the chain I received during a Hindu wedding ceremony. I often get asked whether this is the 10 Commandments from a shop clerk, and it certainly draws attention, and it is a religious symbol, and it's also a symbol of marriage in my religion. Is that conspicuous because it draws that attention? How is that necessarily different from a similar weighted golden cross that someone might wear around the neck? But we don't have to answer that question today. And I want to highlight my agreement with the second vagary pointed out by Ambassador Butler, and that is when you read the French law, which I did not read in the beginning, prohibiting students from wearing signs or attire in public elementary, junior high, and high schools where they exhibit conspicuously a religious affiliation, it's arguably neutral on its face when you read the language. It is not titled the headscarf law, nor does it even include a label of Muslim or woman or headscarf in it. But I think all of us know a fair amount of history to know that there are a lot of laws that might be written this way that might have an impact on particular communities. And again, that's a question we don't have to answer today, but it's an issue for us to think about. As to my own feeling on the first question, I do think that France has violated Article 18.1, and I would agree that the use of the singular "everyone shall have a right," and that this freedom may be expressed either individually or in community with others, is consistent with Charles Ogletree's comment that one person who wants to wear the headscarf, they may be in the minority, but this is the protection that this article ought to have. So unless let me ask the question again, are we in agreement that our unanimous answer to question one is
seems to me we are.
Is yes, so that we can move on.
So we are in unanimous agreement that France's law violates Article 18.1 of the International Covenant.
Does everybody agree with that?
I'm happy with that, and I agree with
I think
that.
The one point that can be raised is the fact that Mr. Schwartz's witness did indeed say essentially that this is restricted to the public school setting, or to there is some kind of alternative that's offered, which is school by correspondence, and we have to consider whether or not. I mean, it's definitely a restriction in the sense that a young lady who wants to wear the headscarf and attend a public school can't, but they're making the provision for her to be able to continue her education, whether or not that makes up for what we would consider to be a violation in this sense.
I think that's a good point, Madam Chairperson, but I'm very attracted to what you pointed out, the absolute character of the language in 18.1, everyone shall have the right. I think that's irreducible. And I am deeply concerned, although it's good that the French government is making alternative provisions as a consequence of their action, such as private education, but I am deeply concerned, and this is beyond our mandate, but I have to say this in response to what you said, Musa, deeply concerned that the French law is a slippery slope. We've, as you said, Shoba, we have all seen history. We know how innocuous sounding bits of legislation like this today can tomorrow lead to horrors. It's a potential slippery slope that I really deeply regret the Parliament of France has put its foot on. And I think we're agreed unanimously that they have made a mistake here.
Yeah. And the language also points here, you have in public or in private.
Yes,
And
yeah.
right there, I think that
And
that,
the-
that
And
is some back to,
counterpose
yeah.
that to the word everyone shall have the
Exactly.
right.
And
And it's a bad situation.
It's exactly what
You
what I was going to, with the fact I didn't bring it up to counter our unanimous decision already, but as an aside, which is essentially if you feel that you have to make some kind of exception
Yeah, I
to
understood
say,
you arguing in
oh
that
no,
way.
no,
Yes, yes.
if you have to make some kind of exception to let people study outside of school, it must be because there's somebody who's being excluded.
Yes,
Right.
quite.
So I think
Right.
that's established.
I agree with that point, and to make my closing remark to your side, I can't help but think of, the failure of separate but equal, right? Or, how you may have separate provisions for someone who may want to express religious belief, but is that really equal?
Mm.
So this, fellow jurors, brings us to our second question. And that is, now that we have agreed that France has violated Article 18.1 of ICCPR, are they accepted by 18.3? Given the law, and I might want to point out here, and I'll take the four persons prerogative to say that we not only have these 5 situations to deliberate on, is there a limitation necessary, and I would highlight that word necessary, to protect public safety, order, health, morals, or the fundamental rights and freedoms of others. But we also have what was not very discussed at all or very little during the trial, limitations as are prescribed by law. So there is a conjunction there, just reading 18.3, and I don't know that we have enough information to dissect that, but I'd be curious to hear from all of you as you also share your opinion about whether France is accepted under Article 18.3.
Chairperson, I too found my eye homing in on the phrase prescribed by law. And in fact, in my notes here, I put a tick. Well, we have law here, the French Parliament's law that we've just decided is not consistent with the Convention, constitutes such a law. But it's absolutely unspecific with respect to these potential exceptions that are mentioned in the International Covenant. It makes no reference to public safety, to order, to health, to morals, or the rights or freedoms of others, does it not? I mean, it just simply makes a prescription and says in the public schools, students will be prohibited from doing X, Y, or Z. And they don't tell us why. And so I don't know what other bits of French law might provide, but we're compelled now, I think, to consider whether what we judge to be France's mistake in this law, so whether or not it's explainable or justifiable or able to be mitigated by reference to public safety. And running through those quickly, because of limitations of time. The 5, I mentioned public safety, it's one of them. Running through them quickly. Public safety, is it affected by what the French law covers? Is law and order? Is order? Order disturbs me deeply for historical reasons. The crimes that have been committed in the past in the name of maintaining order send a chill up my spine. Order? Health? Well, I mean, if it is a headscarf law, what matter of health is affected by that? Morals? And then rights and freedoms of others. I mean, that's a whole book that we don't have time to write or read. I find it difficult to see any of the mitigations here as being available to France in this case, quite frankly.
Sujin.
Yes, personally, I was a little bit persuaded by the second witness of the defense when she was saying that the fundamental rights and freedoms of others when she talks about it. And she, for example, mentioned the Muslim girls who do not want to wear headscarves, and they're rather be forced by their parents or brothers or religious leaders, community, to do that rather than their own choice. So I thought about the rights of those Muslim girls, students, and at the same time I thought about the rights and freedoms of other non-Muslim or students who doesn't have any religion, you know, who constantly has to be exposed to the visible, the symbols of others who has their own religion. So I thought that it's a quite interesting point she made, and I was a little bit, you know, persuaded by that. And then I didn't know the French educational system. They are composed of public and private and correspondence education system. And I presumed that the private system is really, really expensive compared to the public. But I'm not sure how much, I'm not sure the economic, the difference between public and private, but as far as I understand, there is not much difference between each other. So in that terms, I thought that in public settings, I think French is known for its history, wanted to separate the state from the religion for a long time, and they wanted to enforce their philosophy or ideals in their educational system. You know, just in case of public school setting, we wanna make sure that everybody has the equal footing, equal setting, neutralized setting of education. So I thought about those rights of students. So I think that there has to be some balance between the rights of these students and the students who really want to, you know, practice their religion.
I think what we didn't have, or what we lacked in the courtroom, was any presentation of what they referred to as travaux préparatoires, so legislative history, as to we have this law which is just a prescription, but we don't necessarily know what's behind it.
Exactly.
And so when I think of public safety, and this is just my thinking based on what we saw in court, I think of what, you know, there is no concrete example that somebody could hide behind their headscarf to do something. We're not talking about the burqa here. We're not talking about the chador. We're not talking about any of that. This is not a concern about somebody being able to hide a weapon underneath their clothes and bring it to school, or that it could present an immediate public danger. And I actually think, to some degree, when you think about it, you may be fueling a threat to public safety through a law like this, in the sense that the more you ban something like this, the more popular it becomes, and that can lead to confrontation between, you know, the populace and the authorities. And then I think another point that I really thought of, something that I was really hinging on, was this aspect of morals. And I'm not exactly clear as to what the ICCPR actually means by morals, but can we talk about something in the respect of what the French are calling laïcité, and how it's so important, and it has been important in French history since the Third Republic, and it's something that they hang on to so much, that would laïcité actually fall under this moral exception? Which is, I mean, I'm putting that out there. Maybe somebody.
What does it mean precisely?
It's this idea. I mean, maybe there's no great translation of it, but it's this idea of secularism, which is this pervasive secularism.
As in lay, as against clerical, laicity.
Exactly.
I
so I don't know. Maybe one of you has something that can enlighten me in that regard. But I think if I were to think of a moral exception, that's probably where it would fit in. But for the rest of it, I really don't see where an exception, where there's an appropriate exception here.
Well, as far as so is what you're saying that that secularism here would be like the moral that's being protected,
Essentially.
okay, because I see your point, and I think that the place where it gets more complicated is that while it makes complete sense that secularism, you'd want to protect secularism, especially if that's if your culture privileges secularism. The problem, I think, becomes, well, where is that? Who's in power, and where is it being expressed? And so, even when we were talking about like something like separation of church and state, or similar concept, it seems to apply very easily to, well, of course, maybe teachers or staff should not be imposing their religious beliefs on the students who are not in a position of power in this particular setting. However, from the student's perspective, especially if they're not overtly expressing or I don't know, reading passages from a text, but just by simple fact, just wearing something that may or may not be a garment of or a symbol of religious affiliation, that in and of itself doesn't seem to, especially since they're not in a position of authority. Children are not in a position of authority in school. So it doesn't seem that would be imposing belief on other people. It would be different if it was a teacher or someone in a position of power, excluding other people, but not from the bottom up. Right? Top down, yes, but not bottom up. At least that's the way it seems to me that would be where it wouldn't fit, even if even if the culture wants to protect secularism. There needs to be a place where those limits are drawn, because other people who do not want to do that have to have a place to voice their opinion.
And actually, just on the secularism piece, in looking at public safety, order, health, or morals, I think all four of those terms send shivers up my spine when I see how those words have been abused in practice in other legislative formats. Secularism may be the only value, if you will, that was really even raised by the Council for France. And, you know, if we were to give France the benefit of the doubt that by that secularism can be equated with morals in this context, then we still would have to ask the question, is the vehicle for protecting these morals this ban, right? That's yet another question, even if we were to agree that secularity is the equivalent of morals in this context. And that's kind of my itch, among others, with 18.3 and how France has failed, frankly, in my view, to meet this exception, is that these are limitations that must be necessary. And I didn't...
A good point.
And I didn't hear anything today that... I heard a few compelling arguments.
Could I come to the desirable as against necessary?
Yes.
Sujin made a terrific point in referring to the testimony of that second witness on the French government side, the woman of Algerian American descent from Rutgers University. I thought she was superb and compelling. The notion of the brotherhood, pressing these young women to wear a scarf which they say makes them a Muslim, and that's not found in the Quran. That itself seems to me a bit of a swindle, but anyway, that was a terrific testimony, and I have deep sympathy with what she said, and I think you did too, Sujin. But is this the way to fix it? Should a law be made that has such a scope to it, capable of such dramatic misuse, referring to conspicuous display of symbol? Anyway, should a law be made of this character to deal with that problem? I don't think so. That problem needs to be dealt with by that community within its own terms. In that context, I saw a superb film from France 2 years ago, won the prize at Cannes, the French film festival, called The Class. Have a look at it.
Did see that.
Yeah, it's about a high school class in a working class suburb of Paris, which has all these issues in it. It's mixed race, it's mixed religion, mixed gender. It's a brilliant film, that's why it won the award, and it shows that these problems can be worked out by the community. Making a law of the kind the French Parliament has done, it seems to me, is a very heavy and blunt instrument, and that's part of the problem. I'm sorry, I didn't mean to interrupt you, but
no,
but
it's good to have a stream of consciousness point so that there's so that it's smooth. I would also add to that you know, I haven't looked at, you know, how do other states that consider themselves to be secular, is this how they would deal with the problem, right? But I think that point was also well made by the witness for challenging the law, Professor Bowen, when he talked about, you know, do you want to use, is this really a cover, no pun intended, for something else? Do you want to hide under the real problem by passing a law like this, or do you want to face what may be discrimination or inequality head on? And I thought that was a interesting related point that was made by the witness for challenging the law.
I think something that was never clarified for us throughout the proceedings, and this goes straight to the point of necessity, is this law, the French law, targets specifically students, but it doesn't address anybody else who works in the school setting, and who enters the school setting. Can therefore a teacher who works in the school setting, can somebody who works in a ministry wear a headscarf? Because if the idea is to keep, you know, this religious affiliation completely separate from the public domain, then this law specifically is only targeting students. And is it as necessary? I think it puts the question of necessary back on in the forefront in my mind. But I also think about what the defense did say about infringing on the freedom of others, and essentially the idea of you're putting the freedom of this minority, and they would stress that it's a very small minority of women who actually want, or girls who actually want to wear the headscarf, before that of everybody else who has to be subjected to seeing this religious affiliation.
I think that there are a couple of more interesting questions here, especially when we're talking about a minority, but of minors, of children, essentially, who did not get to probably voice their opinion or vote or what have you in terms of enacting this law. Especially that video that we saw at the opening, the Muslim community was estimated about 10%, but under 25 was 20 to 30% of the people under 25. So a much higher number were being affected without representation, essentially. I think that said, I think that the most compelling argument for or in favor of this law that was made today in court was the fact that there were cases, even though there weren't very many explicit or specific cases brought to our attention, but that the argument was made that there are children, young girls, who are affected negatively and whose maybe health may be at risk, mental health, what have you. There are a number of ways of describing health, but maybe that their fundamental rights were being violated. However, at the same time, so I thought that was the most compelling argument made today. At the same time, I agree with Ambassador Butler in saying that it doesn't seem like this is the right way to go about. Right. So, I mean, if you're really interested in protecting this very even smaller number of people who may be subject to coercion or being forced, well then it seems to me that something along the lines of laws that we have in order to protect children from child abuse, right, would be more appropriate, but not one that bans, you know.
Well, that's what made the most compelling argument, in your view, a very weak argument, in my view, because the vehicle was just simply a poor
wrong
one.
instrument.
But just getting to, because I certainly had the thought of, why does this apply to students only? And the only potential argument I heard was the fact that they're of a tender age, and would there be some type of a chilling effect by not having a law like this, because people who choose to wear the headscarf would point fingers at those who didn't. But again, I personally didn't find that convincing.
Well, and children point fingers at each other all the
All
time.
the time.
I mean, it's not something that's religious or
It's very
culturally
complex.
specific.
If you ask the wrong question, you get the wrong answer. If you do whatever you do, you should do for the right reasons. This is the wrong reason. I actually think the way ahead would be an education program to try to help young people understand that when they're told they must wear a headscarf because that's what Allah requires, they're not being told the truth. It's a cultural practice. It's not a religious requirement. I mean, that kind of thing needs to be done. But that's another subject for another day, and that's far distant from making a law of this kind that could be so dramatically misused. It could be a terrible slippery slope, and I think it's the wrong thing to have done.
So I know we have to wrap up pretty soon, and I don't know where all of us might be, but I have a sense on the second question. But why don't I restate question number 2, and we can go around and get a final decision if you think we're ready for that part of our deliberation. Okay. We have all agreed that France violated Article 18.1 of ICCPR, and our second question is whether France is accepted by Article 18.3 of ICCPR.
No.
Actually, can I add one more?
Sure,
Yeah.
absolutely.
I thought about these Muslim young students, girls, who doesn't wish to wear headscarves. And you mentioned that they are a very tender age, right? They're very vulnerable to be affected or forced by the other people. So I thought that these people and the other people who really, really wants to practice their religion by wearing the headscarves, I really wanted to look at both groups in a deeper level. So I thought that personally I wanted to protect these people because they are very tender age, from 9 to 16. They're a very tender age, so I thought I wanted to give a vote that I think this French law could be, this limitation can be subject to the exception of 18.3. My
Okay.
personal opinion about that.
I'm still hinging a little bit on morals because I think, once again, that's where the idea of laïcité comes in, and I'm wondering whether or not it's an adequate understanding of how important that is in French society and whether or not we have that adequate understanding. But even then, it's really marginal to say that that would fall under morals, because that was not the argument that was presented to us. The argument was not fashioned in that way. So for all intensive purposes, for me, there is no exception, because there hasn't been enough evidence, or there hasn't been enough of an argument that it would fall under that exception. So there is no exception in my opinion.
That's it?
Well, I think that this law probably had on some level had good intentions behind it, but again, I don't think that this is the right way to protect this. If there are minors here who do need protecting, that this is the right way to protect them. So I'm very much I think that no, they are not accepted under this because in fact it is impinging on the fundamental rights and freedoms of others, the young girls who do want to wear headscarves. And I mean, even though we could have a whole other debate about whether or not a 9-year-old could or has the appropriate agency to decide one way or the other about a religion. But that's not even up for debate at this point.
It's a whole other subject.
It is a whole other subject, but it's one that I think that
needs to be had.
Could very easily. I mean, if you wanted to take a very nuanced approach to finding a law that was inclusive, that would also need to be addressed in that discussion. But the way it's set up here, I makes me come down on the side of no, that they are not accepted under these, because and what was presented today didn't seem to even prove that case. I mean, even if we had maybe more specific evidence or specific cases, but they were not presented today.
I agree with that.
And for my own opinion, I do believe that 18.3 was written with good intentions, and perhaps is even being applied with good intentions as well by the French government, but feel like there was a failure not only in the sufficiency of evidence, generally speaking, but in even coming close to meeting this necessary language that lies in Article 18.3, that no one even made an overt association between any reason and any of these, at least 4 out of the 5 items. One could argue that the Rutgers professor at least touched upon the fundamental rights and freedoms of others, makes it difficult to even have the other important conversation of whether it was necessary. And so for that reason, I am going to have to vote no on whether France qualifies under the exception. So what I've counted for the second question is no for Ambassador Butler, yes for Sujin, no for Musa, no for Lisette, and no for myself.
Correct.
Thank you, fellow jurors. I think
Thank you
we've
for a
made a
wonderfully
decision.
effective job. You've done well.